We continue to see evidence that the Ninth Circuit does not know how to operate under the purview of Bruin, this time in an order handed down in the Boland v. Bonta challenge to the California handgun roster. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, we see more unprecedented and truthfully weird things coming out of the Ninth Circuit. It seems to be a little bit of a trend. This time it is happening in the Boland v. Bonta case. Here to talk us through it, though, is an attorney at Michel and Associates representing CRPA. That is Alex Frank. Alex, how are you today?
Good, Kevin. Nice to be back.
Absolutely. But before we get into that, as always, guys, it is working. The algorithms are turning in our favor, and it's because of what you're doing on your end. So please continue to like, share, and subscribe to these videos and to this channel. Hit that little notification bell so that you get notified as soon as we come out with important videos like these. As always, we want everybody to be as informed as possible as they go to the ballot box in November in those general elections. So, Alex, I guess before we get into the actual order, which is ginormous, can you go ahead and just give us a rundown? What exactly is Boland, and what has brought us to the Ninth Circuit with Boland today?
Sure. So the Boland case, Boland v. Bonta, is CRPA's lawsuit that challenges California's Unsafe Handgun Act, which we all know as the roster. So in order to sell a handgun in the state of California, the handgun has to comply with the roster or otherwise be exempt from it. And what that basically means is that if you're not a police officer and you walk into a gun store in California, you will notice pretty quickly that the selection that you have to choose from is very dated because as of 2013, semi-automatic handguns must be equipped with micro-stamping technology, chamber load indicator technology, and magazine disconnect mechanism technology. And while some semi-automatic handguns do have chamber load indicator, I mean, very few do, but some do, and even fewer have MDM technology, there are no handguns on the market anywhere in the world that we're aware of, or that anyone's aware of, that are equipped with microstamp. So because that became effective in May of 2013, nothing introduced to the broader national marketplace that you could, for example, walk into a gun store in Utah or Arizona or Texas or, 48 or 49 other states can buy. You can't buy here. So we filed a lawsuit alleging that is unconstitutional. And we had some really good luck back in March of last year. We got the district court in Orange County, Judge Carney, to declare those provisions of the Unsafe Handgun Act unconstitutional. And that went up on appeal. The California Department of Justice appealed that to the Ninth Circuit. The Ninth Circuit heard oral argument in August of last year, and we were awaiting a ruling, and we got not exactly a ruling, but there was movement in that case yesterday, March 25th.
So I guess just as a consequence of the lawsuit itself, we challenged for a preliminary injunction on the magazine disconnect mechanism, the chamber load indicator, and microstamping. We have already seen something good come out of this lawsuit, though, right? And we've done a couple videos on this in the past because when the state appealed this to the Ninth Circuit, they left microstamping off of that appeal. So we have been able to see some new handguns come onto the roster, but then, yeah, we go through these oral arguments, and then we get hit like this. And like I said, guys, I already said it's ginormous. Jacob, if you could put this order on the screen in its entirety, it reads like this. Submission of this case is vacated pending the en banc decision in Duncan v. Bonta. That's the entire order. So I guess this probably leaves you and me and a lot of other people wondering, what in the world does this actually mean? Submission of the case is vacated. I mean, since yesterday when this order came out, what sense of this do you make?
Sure. So that order basically means that instead of issuing a decision on the case post submission. The Ninth Circuit is basically going to do nothing and just basically keep the case in limbo pending further guidance legally that the court anticipates the resolution of the en banc panel's rehearing of the Duncan v. Bonta case to provide. So the way it works when you go to court, and this is true in both the trial court and in the appeal court, is that you you go to court, you present your oral arguments to the judge, or in this case, the panel of judges, and then shortly thereafter, they'll usually issue just a brief order that just says the matter has been submitted. And all that basically means is that briefing is closed, arguments are closed, the ball is now in the judge's side of the court, and they're going to, in due time, issue a decision in the case. So what this order issued yesterday tells us is that they are not going to issue an order until they see what happens with the resolution of Duncan. So the submission of the case and the court's obligation to issue a decision is sort of temporarily suspended pending the further developments in Duncan.
But we've seen that before, right? When Bruin was going through the Supreme Court, we saw several cases get held up. Even when Duncan was originally going through the Ninth Circuit, we saw several cases in the Ninth Circuit get held up. Is that an interpretation in the past that we were making, those cases being held up, waiting for a decision? Because I have never seen an order like this before. Why is it that for this specific case, we get an order coming out like this when this seems to be something that's happened so many times in the past?
Probably because the judges just decided that it would be probably better to do that than to sua sponte stay the case. It would have the same effect, and it doesn't really tee them up for us to go in there and try to undo it. It sort of leaves it in a slightly more ambiguous procedural position than the other ways that they could go ahead and do this. And in the past, what happened was that there was this bottleneck of cases, especially in the Ninth Circuit, of Second Amendment related cases. And the bottleneck built up and everything got stayed pending the resolution of Duncan. I'm sorry, not Duncan, pending the resolution of Bruin at the Supreme Court. So this is sort of similar to that because Duncan is the case that is the most high profile Second Amendment case in the Ninth Circuit at the moment. And whenever a case is heard en banc, that is important because it signals that some very serious precedent is going to come down that's going to impact any case whose issues are being litigated under whatever the legal standard is that the en banc, the forthcoming en banc opinion is going to bear on. Now, it's disappointing here to see them do that because this case was taken under submission in August of last year, and the Duncan en banc panel argument was submitted last week. So, you can say, like many of us are saying, like surely lots of people on Twitter are saying that this is calculated and they just didn't want to rule, which, we don't know what's going on at the Ninth Circuit. We know what the composition of the panel of judges is. We know that Berzon has historically been not a friend to the Second Amendment. We know that Rawlinson probably isn't either, although we don't know much about her stance in the Second Amendment because there really isn't one. We can anticipate that Judge Bress would have been on our side, but yeah, it's disappointing that they decided to wait when they probably could have issued a ruling before. But historically, whenever there's cases trickling up the or sort of down the road procedurally that can potentially resolve or bear on many other cases, it's not uncommon, like you said, for courts to kind of hit the brakes or for parties to even hit the brakes and say, pending what's going to happen in this case, we should stay this case, or for a court to basically reach the same outcome by doing what it just did here in Boland. It's not uncommon. The way they did it is a little unusual, but the ultimate result is not uncommon.
Well, it seems like the eyes are always looking upward. I'm sure at in some way, shape, or form there are implications in the same manner for Rahimi, which is at the Supreme Court. I have talked with Chuck Michel a little bit, and something that he did say was coming was that the Ninth Circuit was really looking for their identity and the way that they're going to operate and figure out how they're going to operate under the Bruin decision. Would you categorize this as kind of a product of an idea like that? I mean, we're waiting on Duncan to see how the en banc panel decides to rule, and that's going to set a precedent for the way that this three-judge panel is going to rule?
Rahimi should be released in the near future. And so, technically, right, like the Ninth Circuit en banc panel should really do what the Boland panel did, is say, we're gonna pocket this and not rule until Rahimi comes down, right? Using the same logic, right? Because there's a higher court that has that will imminently, ostensibly bear on the legal issues that we have to apply here. So it's the same reasoning really should apply, and whether they announce it or not, it's probably what is going to happen with the Duncan case, is that Rahimi will get issued. But Rahimi, the issues in Rahimi won't necessarily resolve Duncan, and the issues in Rahimi won't necessarily resolve Boland. And the issues in Duncan won't necessarily resolve Boland. The Boland case is a handgun ban case. It's arguably not a case that requires Bruin to even to answer it, and ostensibly doesn't require Duncan to answer it because it's probably answered under Heller. And Rahimi is this question about prohibited persons, basically. And Duncan is a question about large capacity magazines or standard capacity magazines, depending on how you view the issue. And Boland doesn't involve either. So the real issue is Rahimi and Duncan going to change the application of the Bruin/Heller framework of how we look at Second Amendment cases? And it would surprise virtually everyone if Rahimi changed it in any material way, because Bruin is a 2-year-old case. And although the Supreme Court does tweak its precedents, they don't tweak them that quickly. And the same panel that ruled on Bruin is the panel that's going to hear Rahimi. So it would be really cataclysmic to see the same panel modify its Bruin precedent in any negative way. If anything, we would expect them to clarify it and make it stronger. But we can't say the same for the en banc panel that's going to hear Duncan. We anticipate that the en banc Duncan panel will do something that we don't like, to try to, in its quest to figure out how it's going to find its footing and its identity as far as how it interprets Bruin. We all know the Ninth Circuit hasn't historically been good with Second Amendment cases, so there's reason to be nervous about that. But an en banc panel in the Ninth Circuit actually isn't all of the judges. It's a smaller impanelment because there's so many judges on the Ninth Circuit, and we know that the en banc panel that's going to hear it, the composition isn't great. So the future, we don't know. We can't predict it, but we think virtually everyone expects the en banc resolution of Duncan to go up to the United States Supreme Court, regardless of how it pans out. So we'll just have to wait and see. It's going to take some time to know, unfortunately, but there's not much power we have over that.
Well, I guess, yeah, you got 14 words in this order, giving us a lot to potentially look at, not just with Boland, but with other cases. We're certainly going to follow all of these cases and continue to report them on this channel. I guess, Alex, you kind of alluded to it. Aside from the virtue of patience, what do we have to look forward to specifically in this Boland case?
I would say what we have to look forward to is the fact that we don't have anything negative to look forward to. So, well, actually, let me give one caveat to that. What do we have to look forward to give you a square, straight answer to your question? Is in the interim, nothing's really going to change. Manufacturers that are able to equip guns with CLI and MDM will still be able to do that. And we have options in the district court as far as, we'll have to regroup and figure out what we're going to do in the district court, if we're going to take any action or we're just going to wait. But in the interim, nothing's really going to change. So all the benefits that we got out of the preliminary injunction order, which struck down microstamping and then subsequently microstamping was repealed, means that all these new additions to the roster, like the 320, the 365, the Hellcat, the VP9 series, and some other stuff. The reasons why those semi-automatics are able to be added still apply and apply today just as much as they did before the order, because the change in submission of the matter doesn't change the status of the injunction. People need to know that. So nothing bad has happened because of that. And good things could potentially happen in the future. We just don't know when or what they're going to look like. But for now, nothing bad has happened. So that's something we can look forward to. Judge Carney's still our judge, which is good. So if we take action, we can anticipate that we'll get a resolution that is at least as good as the one that we got already. And Supreme Court precedent with Rahimi could very well make things a lot better for us. It could narrow down the wiggle room that the Ninth Circuit has to do anything that we don't like. So that's a reason to be optimistic. And the panel at the Supreme Court is good. That's a reason to be optimistic. So yeah, there's good reasons to be optimistic. There's reasons to cabin that optimism, as I've discussed. But as far as the injunction goes and the Boland case goes, we appear to be in good footing.
Well, you don't got to tell me twice. Silver lining is definitely something good to look at. Alex, I know that you guys are super busy there at the law firm. I want to thank you for taking the time to come on and explain this to us. Look forward to hearing more from you in the future.
My pleasure, Kevin. Anytime.
Absolutely. And guys, if you like videos like this and want to continue seeing content on Second Amendment litigation, legislation, and what is going on with the culture in California, please, one more time, be sure to like, share, and subscribe to these videos and to this channel. Hit that notification bell so that you get notified when things like this happen as quickly as possible. As always, we want to make sure everybody is armed when they go to the ballot box with this information in November for those general elections. Thanks, guys, and we'll see you on the next one.